Imagine spending 22 years of your life loving someone. 22 years of cooking their meals, washing their clothes, sitting beside them in hospital waiting rooms, holding their hand through every diagnosis, every setback, every quiet and painful night. Imagine giving the best years of your life to a person you trusted completely, to a family you welcomed with an open heart, to a marriage you believed was permanent and safe and real. And then imagine waking up one morning, the week your husband is buried, and discovering that everything you thought was yours is already gone. Before we go any further into this story, we want to hear from you. Go ahead and drop a comment right now telling us where in the world you are watching from. We would love to hear from you, and don't forget to hit that subscribe button so you never miss any of our upcoming videos. Now, let us get into this. Margaret Collins was 52 years old when she found out that her entire life had been quietly and legally dismantled without her knowledge. She had not gambled her money away. She had not made bad investments. She had not abandoned her responsibilities or run from her marriage. She had done everything right, at least everything that society tells a woman she is supposed to do when she marries into a family with old money and a long memory. She loved her husband, she managed her home, she sacrificed her career advancement to be present for him through his illness. And when he died on a quiet Thursday morning in March of 2021, she sat beside him and held his hand until the very end. What she did not know, what nobody had told her, what her husband had never once found the courage to say out loud, was that his family had already been to a lawyer. They had already restructured the accounts. They had already rewritten the trust documents. They had already decided, among themselves, without her present in any room, what Margaret Collins would receive from 22 years of marriage. And the number they had settled on was $40,000.
Not $40,000 a year. Not $40,000 as a starting point for negotiation. $40,000. Full stop. That was the check Richard Hargrove, Thomas's older brother, the architect of the entire operation, placed on Margaret's kitchen counter 72 hours after her husband was in the ground. He was polite about it. He was well-dressed and calm, and he used the word generous without any trace of embarrassment whatsoever. He told her the house now belonged to the family trust. He told her the savings accounts had been frozen pending estate processing. He told her the investments were being handled by the family's legal team. And then he straightened his jacket, looked her directly in the eye, and said words that would later be documented in a court deposition word for word: "We hope you'll be comfortable." Then he walked out of the house that Margaret had lived in for 18 years, got into his car, and drove away. He was not worried. He had no reason to be worried. He had checked everything. And he had missed one thing. One single piece of paper, sitting in a cardboard box in the corner of a storage room, in a folder Thomas had labeled Old Miscellaneous, in fading ink sometime in the early 2000s. And that one overlooked document was about to cost Richard Hargrove and his entire family far more than they ever imagined possible. Now, to understand how any of this happened, to truly understand it, you cannot start with the day Thomas died. You have to go back much further than that. You have to go back to a small working-class neighborhood in Columbus, Ohio, in the early 1970s, where a girl named Margaret Collins was growing up in a house that did not have much money but had something arguably more valuable: a mother who kept meticulous household accounts in a green spiral notebook on the kitchen counter. Margaret watched that notebook her entire childhood. She watched her mother write down every single dollar that came in and every single dollar that went out. She watched her parents sit at the kitchen table on Sunday evenings and review the numbers together, calmly and deliberately, the way some families read scripture. That notebook never left Margaret's mind. When she grew up, she did not inherit great wealth. She inherited something better. She inherited the discipline to understand exactly where she stood at all times, financially, practically, and legally. That discipline would one day save her life. But we are getting ahead of ourselves. Margaret put herself through Columbus State Community College while working part-time at a dry cleaning business owned by a family friend. She earned her bookkeeping certification and then spent the next several years working her way up through small businesses across central Ohio, building a reputation as someone who was not just technically competent but genuinely trustworthy. Clients who hired her for tax season kept her year-round. Business owners who needed someone to manage their accounts quickly learned that Margaret Collins was the person you called when you wanted it done right and you wanted to sleep at night knowing it was done right. By her mid-30s, she had built a genuinely independent financial life. Not luxury. Not comfort in the way that rich people use that word. But stability. Savings. A sense of security that she had earned herself, with no help from anyone, and that nobody could take from her. Or so she believed. She met Thomas Hargrove in the spring of 2003 at a financial conference in downtown Cincinnati. Margaret had been invited to present a workshop on bookkeeping systems for small business owners. Thomas was in the back row of that workshop, which struck her as slightly odd because he was clearly not a small business owner. He was too well-dressed, too relaxed, too certain of himself in the way that men who have grown up with money tend to be, not arrogant, just completely unbothered by the kinds of financial anxieties that drove most of the people in that room to attend a Saturday morning conference in the first place. After her presentation, he introduced himself. He told her that she was the most practical person he had heard speak in years, and that he meant it as a genuine compliment. She laughed, told him it was the strangest compliment she had ever received, and he said that practicality was the rarest and most underrated quality in the world. She thought about that line for 3 days afterward. 6 months later they were engaged. 18 months after that, they were married in a ceremony at a garden venue outside Cincinnati on a warm Saturday in September 2004. And that is where the first cracks appeared, before the marriage was even fully official. Not in Thomas. In his family. Margaret's side of the wedding was everything you might expect from a woman who had spent her life earning her own way. Small. Warm. Genuinely joyful. Her friends from Columbus were there, her mother, her aunt, her colleagues who had become friends over the years. People who hugged her and meant it. Thomas's side of the wedding was a different experience entirely. His family arrived coordinated, the right outfits, the right expressions, the right things to say at exactly the right moments. His mother, Eleanor Hargrove, greeted Margaret at the reception with a handshake. Not a hug. A handshake, firm and dry and brief, the kind of handshake you give a new business associate whose contract you have not yet decided to sign. Thomas's older brother Richard gave what he called a toast at the dinner but was, by any reasonable measure, a prepared speech about the Hargrove family's legacy and the importance of protecting what previous generations had built. He said the word legacy 7 times. Margaret counted, partly because she was a person who noticed patterns, and partly because something about the number made her uneasy in a way she could not quite name. His sister, Diane, was warmer on the surface but watched Margaret throughout the evening with the careful, evaluating attention of someone conducting a prolonged job interview. Margaret noticed all of it. She filed all of it away. And then, because she loved Thomas and because Thomas was kind and present and nothing like the cold calculation she sensed in his family, she made the choice that millions of people in her position have made throughout history. She chose to believe the best. That choice would cost her everything. And it would also, eventually, become the reason she won. The early years of the marriage were, in fairness to Thomas, genuinely good. He was attentive in the ways that matter, he showed up, he listened, he was present in the house in a way that Margaret had not expected from a man who had grown up with people who managed him rather than raised him. They traveled. They built a home together. They had dinners with friends and quiet evenings on the back porch and the ordinary, unremarkable happiness that most people who are fortunate enough to experience it do not think to be grateful for until it is gone. But there was always, underneath all of it, a compartmentalization in Thomas that Margaret could never quite reach. His financial life was his. His family's business decisions were theirs. The accounts that held the serious money, the old money, the family trust money, the real estate holdings and investment portfolios that represented the Hargrove wealth, those existed in a separate world that Margaret inhabited as a guest but never as an owner. She had her own accounts. She had her own income. She was not dependent on Thomas financially, which meant she never felt a pressing reason to push her way into financial structures she had not been invited to fully participate in. That was the comfortable trap she did not recognize she was sitting in. And it was one that Richard Hargrove, watching from a careful distance, had identified years before she did. In late 2019, Thomas was diagnosed with hypertrophic cardiomyopathy, a progressive heart condition that thickens the walls of the heart and over time makes it harder and harder for the organ to do its most basic job. The doctors were measured in how they delivered the news, as doctors often are when the news is serious but not immediately terminal. They told Thomas and Margaret that with proper medication management, lifestyle adjustments, and careful monitoring, a prognosis of 2 to 5 years was realistic. It was not the kind of sentence you receive and then move on from easily. Margaret went home that night and sat at the kitchen table for a long time without turning on the lights. Thomas sat beside her and held her hand. In that moment, whatever complexity existed between them and his family and the money and the carefully maintained separations of their financial lives, none of it felt like it mattered. What mattered was that the man she loved was ill. What mattered was being there for him. And that is exactly what Margaret did. She reduced her client load. She reorganized her schedule entirely around his medical appointments. She became, over the course of the following months, not just his wife but his primary caregiver, managing his medications with the same precision she had always brought to every financial record she had ever maintained, tracking his symptoms, communicating with his doctors, coordinating specialist referrals, and doing all of this while still maintaining a partial income and the household and every other practical reality of two people's shared life. She gave herself to his care completely and without complaint, because that is what you do when you love someone. That is what you do when you made a vow and you meant it. And while Margaret was doing all of that, while she was focused entirely, selflessly, and exhaustingly on keeping her husband alive, Richard Hargrove was on the phone with a law firm in Cincinnati that specialized in estate planning and asset protection. The meetings happened without Margaret present, which is not, on its own, unusual in wealthy families where estate planning has always been treated as a family matter that predates any individual marriage. But what happened in those meetings went well beyond ordinary estate planning. According to documents that would later be reviewed in court proceedings, Richard convened what participants described as a series of legacy protection consultations beginning in the winter of 2020. The core concern, as Richard framed it to the attorneys, was ensuring that upon Thomas's death, the maximum possible portion of the Hargrove family assets remained within what Richard called the bloodline. Not shared. Not divided. Not passed to a woman who, in Richard's private assessment, had been a good wife but had never truly been a Hargrove. The attorneys presented options. Richard selected the most comprehensive. And then the family flew to Cincinnati for a weekend and sat down with Thomas. What was said in that room, we do not know with certainty. What we know is what Thomas signed. The revised estate documents, executed approximately 14 months before his death and reviewed exhaustively in the subsequent legal proceedings, restructured the ownership of the primary marital home into a family trust controlled solely by Richard as trustee. They reclassified two savings accounts that Margaret and Thomas had maintained together for years as Thomas's sole property assets, returning them to the estate upon his death. They redirected the life insurance payout that had previously named Margaret as primary beneficiary. And they reduced Margaret's inheritance, after 22 years of marriage, after every shared meal and medical appointment and quiet evening and sacrifice and ordinary act of love, to a single cash bequest of $40,000. The documents were signed with Thomas's full legal capacity intact. A physician had certified him. The family's estate attorney had prepared the paperwork. Richard's team had even gone to the length of recording a video of the signing, Thomas on camera, calm and clear, affirming that he understood every document in front of him. They had anticipated a challenge. They had prepared for every angle. They had thought of everything. Except one small box in a storage room they never searched. Thomas never told Margaret. In 14 months of daily life together, of meals and conversations and nights when the fear of his illness filled the room between them even when neither of them spoke it, he never once told her what he had done. Whether that silence came from guilt or shame or a belief that it would not matter because she would be fine, or a hope that he might one day find the courage to reverse it, or simply the cowardice of a good man who had made a terrible choice and could not face it, Margaret has never said publicly, because she has handled this story with a dignity that Thomas's family never extended to her. What she has said, in the limited accounts that exist of her speaking about the experience, is that she did not see it coming. Not at the end. Not when he was sick and she was caring for him and they were as close as two people can be when one of them is dying. She did not see it coming because she trusted him. And trust, when it is real, makes you blind to the very things you most need to see. Thomas Hargrove died on a Thursday morning in March 2021. He was 61 years old. Margaret was with him. By Friday afternoon, Richard had begun making calls. By Sunday, the family's legal team had filed the necessary documentation with the probate court. And on Monday morning, 72 hours after the man she had spent more than 2 decades loving took his last breath, Margaret opened her front door and found her brother-in-law on the porch with a briefcase and a check and that single devastating sentence about hoping she would be comfortable. She took the check. She looked at it. She said she needed to speak with her own attorney. And Richard, who had planned every detail of the preceding 2 years with the careful attention of someone who leaves nothing to chance, smiled and said of course. He drove away satisfied. He had no reason to be anything else. He had one. At least, that was what he believed for the next 10 months. Now, before we continue, let us take a quick moment. If you are watching this and you have ever been through something similar, a family dispute over an estate, a situation where you discovered that the people you trusted had been making decisions behind your back, go ahead and drop your story in the comments. You do not have to share everything. Even a single sentence. Because you would be surprised how many people watching this right now have lived some version of what Margaret lived. And there is something powerful about knowing you are not alone. Margaret's first call was to an attorney named Sandra, a woman she had been referred to by a colleague who had dealt with a probate dispute some years earlier. Sandra specialized in marital property rights and estate litigation, and she had spent 17 years in courtrooms untangling exactly the kinds of situations that people like Richard Hargrove spent their money constructing. When Margaret called her, she did not cry on the phone. She was precise. She described the timeline. She described the documents she had been shown. She described the house and the accounts and the check and the conversation on the porch, and Sandra listened to all of it without interrupting. When Margaret finished, Sandra said 3 words before anything else. She said, "Bring everything." And Margaret, because she was the daughter of a woman who kept meticulous accounts in a green spiral notebook, because she had spent 30 years of her professional life understanding that paper is power, Margaret had everything. She arrived at Sandra's office with boxes. Organized, labeled, systematic boxes, filled with every financial document she had touched in 22 years of marriage. Bank records going back to 2005. Tax returns. Property deeds. Insurance policy documents. Investment account statements. Correspondence from financial institutions. Every contract she had ever co-signed. And one specific folder, written in Margaret's careful, deliberate hand, simply labeled, "Our Future." Sandra later told a colleague she had never seen a client walk in that prepared. It took Sandra and her paralegal 3 full days to process what Margaret had brought. And at the end of those 3 days, they had identified 2 viable legal arguments. Neither of them would be easy. Both of them would be challenged aggressively. But they existed. And that mattered. The first argument was undue influence, the legal claim that Thomas had been pressured into signing the revised estate documents while he was medically vulnerable and emotionally dependent on his family. It was a legitimate argument. It was the kind of argument that wins cases when the facts align. Sandra filed it with careful and thorough documentation, laying out the timeline of Thomas's diagnosis, the timing of the family meetings, the restructuring of assets, the exclusion of Margaret from the entire process, and the medical reality of his condition at the time the documents were signed. Richard's legal team, and he had retained one of the most respected estate litigation firms in Ohio, dismantled it in 6 weeks. Thomas had been certified as mentally competent by his personal physician on the date of the signing. The attorney had recorded the video precisely to defeat this challenge. Thomas was on camera, clear and composed, answering questions correctly, confirming his understanding. It was airtight. Sandra had known it might be, but she had needed to try. The second argument was a joint marital asset reclassification, the claim that several of the accounts Thomas had restructured as his sole property had, in practice and over many years, been funded jointly by both of them. Margaret had made direct deposits into one of those accounts as recently as 2017. There were years of shared financial activity that, Sandra argued, established a de facto joint ownership that the restructuring could not simply erase by reclassification. The court reviewed it carefully. Acknowledged the complexity. and then ruled against Margaret on a single technicality that had been buried in the original account opening agreement, a document Thomas had signed alone in 1999, before their marriage, when the account was first established. Under the technical terms of that original document, the account had always been his, regardless of how it had been used in the years since. 2 attempts. 2 defeats. And somewhere in Richard Hargrove's world, there was the beginning of a celebration. Margaret did not celebrate anyone else's victories. She went back to the boxes. She went back to the papers. She worked evenings at her kitchen table, the same table where Richard had placed that check, going through files she had already reviewed twice, looking for anything she had missed, any thread that had not yet been pulled. And on a Tuesday evening in September 2021, 6 months after her husband was buried, 8 months into what had become a grinding and expensive legal battle, she opened a box she had almost decided to skip. It was sitting in the corner of her storage room and it was labeled in Thomas's handwriting, in fading blue ink from what looked like a ballpoint pen from 20 years ago, Thomas, Personal Papers, pre-2000. She had set it aside early on because she had assumed it contained only old records from before their marriage, things that were unlikely to be relevant to their shared financial life. She opened it that evening not out of expectation but out of thoroughness, because thoroughness was how Margaret Collins had always operated. Inside the box were Inside the box were documents from the late 1990s and early 2000s. Old bank statements from an account she did not recognize. Some tax documents from before they met. A letter from what appeared to be a county property registry office somewhere in upstate New York. Some handwritten notes she did not stop to read. And then, near the bottom of the box, a manila folder containing a deed. A property deed for a 4.2-acre parcel of undeveloped land in a small rural county in upstate New York. The land had been transferred to Thomas in 2001 as part of what appeared to be a minor distribution from an older family trust, a routine allocation of a minor asset that had, based on the paperwork, never been folded into the main Hargrove family estate structure. Margaret almost set it aside. The property was small and undeveloped and she had never heard Thomas mention it once in 22 years. But something made her keep reading. And what she found on the next page of that folder made her hands stop moving entirely. In 2004, the same year she and Thomas were married, Thomas had taken that parcel of land and placed it into a small private trust. Not the family trust. Not anything connected to Richard or Eleanor or the main Hargrove estate. A private trust, set up by Thomas alone, through a small law firm in upstate New York that had no connection to the family's primary legal team. The trust was simple. 1 page of operative language, with a beneficiary designation that read as follows: to be held in benefit of my lawful spouse, in perpetuity. Not a name. A title. His lawful spouse. Margaret Collins was his lawful spouse. She had been his lawful spouse since September 2004. And that trust, set up 18 years ago, sitting in a county registry office in a small town in upstate New York, had never been updated, never been amended, never been discovered by Richard's team because they had constructed their search around assets bearing Thomas's name after 2003. The private trust predated their search window by 2 years. They had never looked for it. They did not know it existed. And Richard Hargrove, who had spent the better part of 2 years carefully dismantling his sister-in-law's financial life, had done so with a thoroughness that stopped exactly 1 cardboard box short of complete. Margaret sat at that kitchen table for a long time that night. She did not call Sandra immediately. She sat there in the quiet and read the document 3 more times, slowly, carefully, the way her mother had taught her to read anything important, the way you read it when you need to be absolutely certain before you say anything to anyone. Then she called Sandra. Sandra answered on the 2nd ring. Margaret told her what she had found and read her the beneficiary language word for word. There was a silence on the other end of the phone that Margaret later described as one of the longest silences she had ever experienced. And then Sandra said, "Do not touch that document. Do not tell anyone. And bring it to me in the morning." They spent the next 6 weeks verifying everything in complete silence. Sandra engaged a property record specialist who confirmed the unbroken chain of title on the land parcel. She brought in a trust attorney who reviewed the operative language and confirmed that under the laws of the state where the trust had been registered, the beneficiary designation was enforceable and had not been extinguished by any of the subsequent restructuring because neither Richard nor anyone else had known the trust existed, meaning it had never been part of the estate modification process at all. An independent appraiser was hired to value the land at current market rates. By 2021, the 4.2-acre parcel in upstate New York, raw, undeveloped land that Thomas had apparently received as a minor family distribution and had never mentioned to anyone, had appreciated to a current market value of $338,000. Sandra told Margaret they needed to be completely ready before filing anything, because the moment they moved, Richard's team would respond fast and hard, and she wanted nothing left unaddressed. Margaret agreed without hesitation. They waited. In January 2022, 10 months after Thomas's death and 16 months after the initial restructuring had been executed, Sandra Okafor walked into a county courthouse and filed a trust enforcement claim that was 47 pages long. The filing identified the 2004 private trust, documented the full chain of title, presented the beneficiary language with complete legal analysis, included the independent appraisal of the land at current market value, and attached a secondary claim that Sandra had added in the final weeks of preparation. Because in the course of their verification work, she and Margaret had discovered something else. When Richard's team had moved to freeze the joint bank accounts in the days immediately following Thomas's death, they had done so by submitting a classification statement to the bank's legal department that described those accounts in terms that were not accurate, terms that, when placed alongside the actual account documents and correspondence in Margaret's files, constituted a material misrepresentation. In plain language, they had lied to the bank, and they had done it in writing, on letterhead, with a signature. Sandra added a fraud claim to the filing. Richard received the court papers on a Friday afternoon. By Monday morning, his attorney had called Sandra's office 3 times. By Tuesday, they had called 4 more times. Sandra did not rush to return any of them. Richard's deposition took place in March 2022. Sandra deposed him herself, over the course of a full 6-hour session in a conference room in downtown Cincinnati. Richard was controlled. He was prepared. He answered every question in precise, minimal sentences, the way a man answers questions when he has spent months being coached on exactly what to say. He was good at it. He had been managing his family's affairs and other people's perceptions of those affairs for decades. He remained composed through hours of questioning about the timeline, the estate meetings, the legal restructuring, the bank communications, and the decision-making process that had produced the $40,000 check. And then Sandra placed a single document on the table in front of him. A printed email. From Richard to the family's estate attorney. Dated 3 weeks before Thomas had signed the revised documents in 2020. The subject line of the email read, "Priority assets, do not list." The body of the email contained a handwritten list, photographed and scanned, of specific assets that Richard had instructed be excluded from Margaret's revised inheritance. The list was thorough. The list was detailed. The list demonstrated, in Richard's own words and in his own handwriting, that the restructuring had been intentional, coordinated, and directed specifically at reducing what Margaret would receive. Richard stared at that document. Sandra later described what happened next in a filing as 11 seconds of complete silence. Then Richard asked to speak privately with his attorney. The case proceeded to a bench trial. Both sides agreed to have a judge decide rather than a jury, for reasons that made practical sense on both sides at the time. The judge reviewed every document, every deposition transcript, every piece of evidence that Sandra and her team had assembled over 16 months of preparation. The ruling came down on a Wednesday morning in July 2022. On the trust enforcement claim, the judge upheld the 2004 private trust in full. Margaret Collins was confirmed as the sole rightful beneficiary. The land, all 4.2 acres of it, valued at $338,000, was ordered transferred into her name. On the fraud claim, the judge stopped short of a criminal referral but issued a formal finding of bad faith conduct in the estate administration process, and ordered Richard Hargrove's legal team to pay Margaret's full legal costs. After 16 months of litigation at the rates that estate litigation attorneys charge in Ohio, those fees totaled just over $94,000. Margaret Collins walked out of that courthouse with $338,000 in land, $94,000 in reimbursed legal fees, and something Richard had never once factored into his calculations. Her story. And she was free to tell it. Now, here is the part of this story that most people do not expect. The part that, when you sit with it long enough, reveals something complicated and deeply human about what happened between Thomas Hargrove and the woman he married. Because it was Thomas who had set up that private trust in 2004. It was Thomas who had gone to a small law firm in upstate New York, a firm with no connection to his family's legal team, a firm where no one from his world would ever think to look, and created a document that named his lawful spouse as the beneficiary of a piece of land nobody in his family valued enough to track. He did this in the same year he married her. He did this before his illness, before the family meetings, before Richard's legacy protection consultations and the revised documents and the $40,000 check. He did this when he was healthy and clear-eyed and presumably thinking about the future the way a man in love thinks about the future, with a kind of quiet protectiveness for the person he intends to spend his life with. And then, years later, when his family came to him in that room with papers and pressure and the weight of a lifetime of obligation to a bloodline he had been raised to protect above everything else, he signed what they put in front of him. He signed it and he never told Margaret. And he also never revoked the trust. He never called the law firm in upstate New York. He never updated the beneficiary designation. He never folded that small piece of land into the restructuring because he never mentioned it to anyone. Whether that was an oversight or a decision, whether he forgot it existed or whether some part of him quietly and deliberately left it exactly where it was, nobody will ever know with certainty, because Thomas Hargrove is gone, and the dead do not get to clarify their intentions. What we are left with is this. A man who loved a woman and then, under pressure, allowed a terrible thing to be done to her. A man who may or may not have left one door unlocked deliberately, in a house his family had sealed shut. And a woman who found it. Not because anyone helped her find it. Not because the system protected her. Not because justice is automatic or inheritance law is designed to be fair or wealthy families are held accountable for what they do inside estate planning meetings that nobody else is invited to attend. She found it because she kept every piece of paper from 22 years of marriage in organized, labeled boxes. She found it because she was the daughter of a woman who believed that numbers tell the truth when people will not. She found it because thoroughness, when everything else fails, is sometimes the only weapon left. According to estate planning attorneys who have reviewed cases similar to Margaret's, what Richard Hargrove's team did was not legally unprecedented. 90% of all contested probate cases involve disputes between a surviving spouse and the deceased spouse's family members. Most inheritance theft does not happen in one dramatic moment. Instead, it builds slowly through small actions that are easy to miss in real time. A document is changed, an account is drained in increments, a family member quietly gains control over finances while everyone else assumes things are fine. What made Margaret's case remarkable was not what was done to her. It was what she was able to do about it. One of the biggest warning signs estate attorneys point to is a sudden change to a will or trust late in someone's life, especially when it benefits one person at the expense of others, and especially when the person making the changes was dealing with serious illness or was heavily dependent on the individual who stands to gain. Every one of those warning signs was present in Thomas's case. And not one of them had been visible to Margaret while they were happening, because they happened behind closed doors in rooms she was never invited into. The Hartford +2. After the ruling, Margaret did not sell the land immediately. She drove up to that county in upstate New York on a Saturday morning in August 2022, the first time she had ever physically stood on the property that had saved her financial life, and she walked every foot of it. 4.2 acres. Overgrown grass. A small creek running along the eastern boundary. Trees that had been growing there long before Thomas had ever received the deed and that would keep growing long after everyone in this story was gone. She stood there for a long time without saying anything to anyone. Then she called her niece, a 29-year-old woman who had been trying for 2 years to find affordable land to begin a small organic farming operation, and she said, "I think I have something for you." They worked out a private arrangement, Margaret retained ownership, her niece began developing 2 of the 4 acres under a lease agreement, with a below-market purchase option available in 10 years. Margaret used the legal fee reimbursement, the $94,000 that Richard's team had been ordered to pay, to rent an apartment, rebuild her savings, and return to part-time bookkeeping work. She told Sandra in their last communication that she felt, for the first time in years, like she was living on her own terms. Not Thomas's terms. Not the Hargrove family's terms. Her own. Richard Hargrove did not face criminal charges. The judge's finding of bad faith in the civil proceeding was reviewed by the county prosecutor's office and ultimately not escalated, on the grounds that the conduct, while ethically indefensible, had not crossed the threshold required for criminal fraud charges under Ohio law. This outcome is more common than most people realize. Inheritance theft often goes unreported and unchallenged precisely because the person who has been wronged must use their own money to prove it, and many do not have the resources to fight. The family's estate attorney, who had prepared and facilitated the restructuring documents, was referred to the State Bar Association. After a review period, he received a formal reprimand and a 2-year probationary license. He did not lose the ability to practice law. Whether those outcomes constitute justice is a question every person watching this story will answer differently, and that difference of opinion says something important about how we as a society think about what wealthy families are permitted to do within the technical boundaries of estate law. The Hartford. What is documented in the public record is this. Within 18 months of the court ruling, Richard Hargrove had sold 2 of the smaller properties within the Hargrove family estate, almost certainly to cover the legal fee obligations and the mounting costs of his own defense across the duration of the proceedings. The family that had moved so swiftly and so thoroughly to protect their legacy had, in the process, spent a significant portion of it on lawyers. Fighting a 52-year-old woman they had given a $40,000 check and expected to disappear quietly. As experienced probate attorneys have noted, probate court is where the truth comes out. Judges can compel accountings, freeze suspicious transactions, and force wrongdoers to answer under oath. The courtroom is not just a place of law. It is where fairness can be restored when family dynamics and greed have tilted the scales. That is what happened in July 2022. The scales tilted back. The probate pro. There is one final thing worth sitting with before we close out this story. And it is this. Margaret Collins is not exceptional. She is not a lawyer. She is not wealthy. She did not have powerful connections or a famous family or access to resources that most people do not have. What she had was a green spiral notebook on a kitchen counter in Columbus, Ohio, and a mother who believed that knowing exactly where you stand is the most important form of protection that exists. She had 30 years of professional discipline that had trained her to treat every document as potentially significant. She had the presence of mind, in the worst week of her life, to say to a man who handed her a check and told her she would be comfortable, "I need to speak with my own attorney." And she had, somewhere in a cardboard box in the corner of a storage room, a piece of paper that a man had signed 18 years earlier in a moment of love or foresight or perhaps quiet guilt, a piece of paper that nobody had thought to look for, because nobody believed she had anything left worth protecting. They were wrong. So here is the question we are going to leave you with today, because we think it is one worth genuinely sitting with. Not just as it applies to Margaret, but as it applies to all of us. If everything you had built with the person you love were quietly restructured around you, legally, deliberately, over the course of years, would you know where to look? Would you even know what you were looking for? And would you have kept the boxes? Think about that. And while you think about it, go ahead and share this story with someone who needs to hear it. Not to frighten them, but to remind them that the most powerful thing any of us can own is information, and the most dangerous assumption we can make is that someone else is managing it for us. If this story moved you, drop a comment below. Tell us what you thought of what Richard did. Tell us whether you think Thomas left that trust unlocked on purpose. Tell us where you are watching from. And if you want to make sure you never miss a story like this one, subscribe, hit the bell, and stay with us. Because the next story we are covering involves a business partner, a secret second identity, and a paper trail that stretched across 4 states before anyone realized what was happening. You do not want to miss it.